So this event is to do some training on the Federal Trade Commission's plan to eliminate non-compete agreements. I saw it, read it about a month or so ago, and it scared me. I thought that was something that was crazy to do, and I wrote the FTC, and they told me how I could make an official comment. I plan to do that sometime in the next week because the official comment period closes on the 10th. They said they might extend it. But I attended the Polsenelli Zoom meeting with 900 of my favorite friends. And I talked to Joe about it, and we got the idea that we ought to do a training event down here at Venture Café. So we're going to do that. Paul Hirant and I, try to meet once a month at least. We like the ranch in New City because they have great salsa. And we have their Mexican lunch frequently, so that's good. I'll introduce everybody. You've met them. Names are up behind you. Liz Gross is the expert from Polsenelli that's gone through all of this and done several presentations. Kirk Damman is at Lewis Rice, and I've worked with him back when I was at CET. And Kevin is a newbie. The name is spelled wrong on the chart. There's a T instead of a P.
Correct.
He is the partner of somebody else, patent attorney, that I have used. And Joe is somebody else that we have lunch with and try to work with on startup companies. So we have a great panel, and I happen to know the attendees here too. So I have an order of battle here that has Liz doing the overview. Slide 1.
All right. So happy to be here talking about this. We've gotten to talk a little bit already. So the FTC's proposed rule was issued January 5th, and it would essentially be a near total ban on non-competes with workers. Courts have traditionally viewed non-compete provisions with workers disfavorably, but they have also historically enforced reasonable provisions to protect legitimate business interests like confidential information, trade secrets, customer relationships, things like that. We have in recent years seen a trend toward states limiting non-competes, even either by statute or by court decision. There are 3 states that outright prohibit non-competes. It's California, North Dakota, and Oklahoma. But they do have sale of business carve-outs. There are also, I think, about 12 states that have enacted legislation to limit non-competes, mostly in terms of, if somebody is an exempt or a non-exempt employee, if they're non-exempt, they can't, hourly, they can't have a non-compete. Illinois has a new law that I think it's, in order to have a non-compete with an employee, you have to make $75,000 or more. To have a non-solicit, it's another threshold. So this is definitely the way that we were trending and has been for the last, 5 or 10 years. But the FTC really took a giant, fast leap forward with this rule, right? So, this rule is really a blanket ban on non-competes with workers. We'll get into the definitions, but obviously this is a huge concern for businesses of all sizes, all industries. As of this morning when I looked, the FTC has already received over 15,000 comments. Just for, perspective, normally the FTC receives like a few hundred. So this is something that a lot of people have very strong opinions about. The FTC also hosted a public forum a couple of weeks ago and heard a lot of comments from the public then. And they've received a number of requests to extend the comment period. So currently the comment period closes March 20th. There have been a number of requests to extend the comment period by 60 days. Usually the FTC does that, but we haven't gotten anything on that. But to start, I think we need to start at, this is still a proposed rule. It's not law. We don't know what it's going to look like when it's issued. But as I said, this is sort of the direction that we've been trending in. There was also, and I meant to mention this earlier, a group of bipartisan senators who introduced the Workforce Mobility Act. It's legislation that has been previously introduced, but never made it out of committee. It's also a very broad ban on non-competes, but it does have a few key differences from the FTC rule. So it has a better carve-out for sale of business. It applies prospectively, so we'll talk about this in a little bit. The FTC rule is unique in that it requires rescission of existing agreements. The Workforce Mobility Act would also create a private right of action. So, again, so this is a proposed rule. We don't know what it's going to look like, but something is coming. So I think there's a lot of things that we can be doing to, make sure that we have the best protection possible if non-competes are banned. So I'm going to turn it over to myself.
The next slide.
Yeah. So, just at its most basic level, the proposed rule would prohibit employers from entering into or attempting to enter into a non-compete with a worker, from maintaining a non-compete with a worker, and that's where this rescission is going to come in, or from representing to a worker that the worker is subject to a non-compete, unless there's some good faith basis for believing it's enforceable. So as with all of these things, the devil's in the details. So it's really important to look at the definitions. So especially on employer, worker, those are the main ones for me.
I guess I'm next. I would like to go back for a moment to what Liz just mentioned, slide number 3. Notice, for example, that it violates the rule to attempt to enter into a non-compete, which would probably earn some lawyers a lot of money over the next few years if it's adopted. What the hell constitutes an attempt that fails, but is still actionable? But let me move to slide number 4, the definition of a non-compete clause. It's defined as a contractual term. Notice, well, of course it's contractual. Well, that's an important term. The FTC is pointing out that this is a contract liability that will be created, as opposed to a number of other causes of action that could be used for the same purpose to protect a former employer, some of which are significantly different because they're not contractual. One being something called tortious interference with contract, which I'll get into later. Anyway, it's a contractual term between an employer and a worker. The definition of worker, we're going to just note in a moment, preventing the worker from seeking or accepting employment with a person or another business after the conclusion of that worker's employment with his former employer. Something that definition of a non-compete clause fails to mention is the employee who's trying to move has to be trying to move to a business that competes with the prior employer, and that's not set forth in this slide in that definition, but it's crucial. And indeed, again, lawyers make livings off the definition of compete. Employer is important. You notice it does not cover employees trying to move to a new employment. because I'm not sure, I did not sit in the meetings with the FTC's commission discussing that, but there's a significant difference between the definition of an employee in various legal contexts and simply a worker, which is probably more broadly defined in general terminology, more broadly defined than the term employee. Worker is described here as including independent contractors and unpaid laborers. That doesn't define the word worker. It tells me two kinds of people who are workers. It doesn't define all the other people who might be defined as workers. For example, would a partner be defined as a worker? Well, maybe. And I've made some money myself over litigating what is the true status of a partner.
I'm going to actually pick on another piece of that definition that you did there, which is conclusion.
Yeah.
And the idea of what does it mean to conclude your employment? And we start talking about something like gig economy or, sort of at-will employment. How do you conclude an at-will employment? Because it's, by definition, at-will. You can come and go as you please. So when does this person actually conclude their employment? Those are the kind of things that you bump into with this. And it's, well, are you still an employee because you could come back? Something along those lines. Then does this apply to anybody? Because now it's the always an employee or a possible employee of something. You know what I mean with that? And I think that's in terms of your comment, that was the details. These are the things that everybody's going to be fighting over, and I think the one concern we get into with a lot of these definitions is, to your comment with worker, a lot of them seem very into defining that this is included, but they don't necessarily go into the calculus of what actually is the scope of this.
Yeah, and I think it's important to note that the FTC has been pretty clear that they intend to be very broad with the definition of employer, the definition of worker. They want to cover as many people as possible. The problem is that, so this is what the FTC issued. This is it right here. And the rule is this. So there's very little. So we've got all this discussion in the supplementary information, which we'll talk about, but the definitions, it's not enough. So you're right, there's going to be a lot of fights about who's covered and who's not, because I think we're going to talk about this in just a second, but one of the things that's not covered are non-compete clauses with current workers. So if it's a current worker, you can have a non-compete agreement with them.
Really?
Yeah, it's only following the conclusion.
Yes.
So if you have somebody who's working for you, you can prevent them from competing with you during your
Well, they're working for you.
Right.
Yes.
Right.
addition
So,
to
but
doing
after
it.
that,
Right.
we can't have that restriction in place.
Okay, guess now we move to slide 5. The effect on other contractual provisions. The outline notes that the proposed rule does not prohibit non-solicitation clauses and non-disclosure agreements. Non-lawyers here won't realize that that non-solicitation clauses, I'm going to guess, but I think it's a pretty good guess, that the FTC staff, when coming up with this language, intended that the term non-solicitation clause referred to clauses preventing the moving employee from soliciting the customers of the former employer, as opposed to soliciting the employees. And frequently, in these cases, when an employee leaves his or her former employer, they not only want to go solicit their former employer's customers, because one of the salesman's customer base is his or her living. But they also want to bring with them employees they've worked with the former employer, because they already know they can work with those people. And I'm going to guess, and I've not read the rule myself, and I hate to admit that. Just, can you tell what it?
Yeah, so I don't think that, well, the FTC doesn't like those type of provisions anyway, those no poach provisions, certainly between businesses, they don't like those. I don't know that the FTC cares as much about the employee solicitation as just saying to someone, you cannot go work for a company.
And I think that's sort of the history of the FTC's involvement over the years.
Yep.
It's not, but you're right, the FTC is anti-poaching of employees, but not to the same level of intensity.
Right.
Okay.
I think you also bump into this issue in conjunction with non-solicitation clause sort of around your case, particularly of employees. A lot of solicitation of employees can occur before the employment ends.
Yes.
And so you're going to now bump into a lot of those things like you can't represent that you have a non-compete clause. Well, what if I got to convince you have a non-solicitation clause? Which tells you you can't actually tell, where those things bump into each other. And again, that sort of concludes employment again. What does it mean to have these kind of clauses in something where this is work that would potentially be done, again, solicitation of clients or particularly of other employees, before somebody leaves?
Well, but in that case, I mean, that can be prevented during or after employment.
Yeah.
But we also have other protections through common law, so duty of loyalty and things like that. So we will have protections regardless of whether that's in place.
It just seems like it's an interesting potential concern.
Yeah.
And that idea of it doesn't seem like these things have been designed to mesh together. That's the way I kind of put it. You end up with these concerns of, hey, a non-solicitation clause, but we're not saying whether or not it's before or after employment. Are you not allowed to do it before employment, but you're allowed to do it after employment? But wait, if it's contractual, you're not allowed to do it either. Just concerns like that. So.
I think it's also the characterization just as a whole. This is paramount to the employee being able to leave and go to any other employer that may or may not compete. As earlier, we've left all these other questions to be answered, perhaps with the 15,000 comments that we received.
Right. Well, I mean, as I said, the rule is 5 pages, and there are just there's so many holes. We don't know what the FTC is how they're going to interpret some of these other gray areas.
Well, you might call this next point a hole. Or you might call it an attempt by the FTC to close the hole before it starts. That is, the proposed rule includes a functional, what it calls, and what Crashlands called, a functional test, preventing the present employer from using other clauses against the employee that serve the same purpose as a clear non-compete agreement. And the one it mentions in particular is the non-solicitation clause. And the FTC staff includes lawyers, clever beings that those people are, who might just well name something a non-solicitation clause that actually prevents the employee from competing in the business and in the idea that the subject matter of the former employer. And also we might use a non-disclosure agreement for the same purpose. The FTC is pointing out that clever though you lawyers are, we're not going to let you get away with doing that. I think, Paul, you're
real quick, within the context of what you just said, what do you mean by solicitation?
Good question. As most lawyers would say, that depends. But to get right down to it, when most people use the word solicit, they mean for the moving worker. After moving, or maybe trying to do so before moving, goes out to the employees of his present employer and says, hey, I'm going over to Smith & Jones. why don't you come with me? Why don't you
Okay.
keep your business with me?
Same thing with customers.
And with customers.
Gotcha, okay. Thank you.
I had just,
Yes,
not to be too technical, is the functional test, is that written into the proposed rule? Does it give you
Yes.
kind of a logic algorithm that you can go on it?
No, well.
Radiological or?
Yes, the
We'd say
functional
now.
test is included in the rule. No, it's not. It's more of a, I'll know it when I see it kind of thing.
So it's kind of in the
It's
commonish
basically-
law kind of area, like, oh, this is what I think is functional.
Yeah, so it's basically, you know, if it's a de facto non-compete, I don't care what you call it, it's not okay.
Yeah.
So if you say to someone, you know, well, this training costs, so sometimes you'll have agreements with employees that, you know, we're gonna pay for this training, and if you leave within a year, you have to repay it. If you had something that, you know, a repayment agreement where the repayment is not related to what the actual cost was, you know, it's prohibitive for the person, they can't leave because they can't pay it back, that could be a de facto non-compete. So that's what the intent is, like how does it actually play out in this situation? So it's, yeah.
So like a Scientologist that's got a contract that has gotten them clear for over $1 million could still exit saying that I don't really, there wasn't the actual incursion of $1 million and getting that clear.
Well, that is not in the context of a worker though.
Fair enough.
The way I read it, the other example that they give in the proposal is, it's more on the confidentiality side of things. It's disguising NDA as a non-compete agreement. So they give an example of a securities firm where the NDA says you can't disclose anything relating to the securities industry and an employee. Well, that is just too broad in scope that it's going to be a de facto non-compete, even though it's guised as an NDA.
And I think, so the other thing that this highlights, and I think we'll talk about it in a few of the later slides, is that, so the FTC is trying to have it kind of both ways. So we've got this functional test, you can't use an NDA that basically functions as a non-compete. But don't worry, employers, you've got protections under the Uniform Trade Secrets Law and the Defense Trade Secrets Act and Trade Secret Law, which, you can get injunctions if people are, so there's some tension there because you're both saying you can't have something that functions as a non-compete, but you can get all this stuff under these laws, which
Non-compete.
right. So there's
It's not a non-compete.
right. So there's a lot of tension between where the FTC is trying to say you've got all of these other ways that you can protect this information and the things that you can't do. It doesn't really line up.
I think one of the examples you get into, and the way I'm kind of looking at some of this, I think around it is we're seeing more of this functional test type of thing popping in where it's, what are you calling it more than what does it do? And the example I use, and I'm just going to sort of pick on it, is how many people think they actually own these? How many people think they actually own these?
Oh,
When you go and you look at your contract as to what it is, oh, it's a rental agreement, or you're making lease payments on it. Well, that starts to look a whole lot like you owe training, costs and things like that. Those are becoming more and more common. And so we start to see the idea of, okay, well, you can't, hide training costs and say you don't do it, but we're also seeing those kind of things becoming much more common all over the place. We'll provide you with something, you reimburse for it. And then what I really worry about in conjunction with the idea of, that you can't sort of do training costs is in industries where you have, I guess I'd say, unique sort of employment arrangements. And the example I think of is the record industry, where you've got somebody who comes in and you're going to be paid a very large advance that you have to pay back. And the reality of it is the vast majority of bands and artists never do. So can they leave? Because presumably they have to pay back that advance in order to be able to leave.
Like the question there is, are they a worker?
Are they a worker?
So,
Yeah.
we'll talk about this too. If they're not a worker, the rule doesn't apply.
But those are the kind of things I think are we going to see, for lack of a better way of putting it, magic words start to appear around these, where people are finding ways to say, hey, these things aren't non-competes, but effectively they become non-competes. And what the FTC is presumably trying to do here is stop that. They're trying to stop employers from being smart alecks. and trying to say, hey, we'll find a way to make it a non-compete without it being a non-compete. But the worry with it is that lawyers are going to do that. And
Well, and I think it's by necessity in a lot of cases that companies will need them to do that.
Exactly, yeah.
Protect.
Well, in the securities industry, making employees pay for their training is a significant and commonplace cause.
And it's not that you can't make them repay the training costs, but it has to be that it's actually
Connected.
what the cost was, or, some falls off every month, or something like that. There's got to be a relationship to what the cost actually was.
Okay, ready? So to the rescission, as Kirk hit on earlier, it also speaks to the inconsistencies of how the rule is drafted. So you can see the rule behind, hopefully. So employers under the proposed rule will be required to rescind non-compete clauses within 180 days of the effective date of the final rule. My interpretation is that is a rescission of existing employees without affecting their other contract terms. It would just essentially render the non-compete unenforceable moving forward. Again, 180 days from the effective date, which we don't know when the rule could go final. It could go final without any changes, amendments. The period for comment could be extended. So there's no timeline set that where this might go into effect. But the point is 180 days from whenever that date is made final. In addition to existing employees, they would provide model language 45 days after, but you would also have to notify former employees whose non-competes were still in effect. This is really the employee, I'm not going to say employee, the worker class that is really most affected by this. A current employee that has a non-compete, maybe they're precluded from looking for other jobs because they're scared of what may happen if they were to leave. But it's those individuals that say maybe they left a year ago and they non-compete for 2 years. The employer has an affirmative duty to notify them. It's now rescinded, and you're free to go work for a competitor. Again, my reading and characterization of the proposals, that is their primary focus.
I think it's also really important to note that you can't just send out like a blast email. It has to be an individualized communication to the employee. And I agree with you that the piece on the former employee is that's going to be the biggest impact of this requirement. But the other thing, and I think we'll probably talk about this later too, is if you've got a contract that has a non-compete in it, and you have to rescind it, does that contract have sufficient severability language? Or can we just pull that out of there? How are we going to, address all of that and making sure that those provisions are still in place? And did we give that person consideration for the non-compete? Did we pay them a bonus for that non-compete? Well, now we no longer have that protection, so what are we going to do? And those are some of the questions that we don't have answers to. Is what do we do with those amounts that they got? They got the benefit, but
So they can prohibit a bargain for transaction or bargain for exchange kind of idea? Is that what they're saying? Those are prohibited now? Is that an implication?
It doesn't matter if you've paid them for the non-compete. If they're a worker, you can't have a non-compete.
Period.
How many times did you actually see in your practices where workers actually got specific compensation for agreeing to submit to a non-compete?
Often.
My experience was never. And
Yeah, so in a lot of states, continued employment or new employment is sufficient consideration for a non-compete. In a lot of states, courts will look at whether there's been some consideration in addition to that, and whether they are willing to enforce that provision. Some states, though, new employment and continued employment is not sufficient, so you have to pay them something else.
Yeah, so that it is contained, so long as it's expressly bargained for.
No.
Or is it
It's-
prohibited, you can never bargain for it?
You can never bargain for it if you're
Okay,
working.
so now so it becomes an illegal transaction. Do you intend?
violation of contract, not necessarily otherwise.
Well, I mean, I'm talking civil.
Well, that's what, maybe it's on your next slide, is is there actually indications of the penalties for failing to do this?
No, so I don't, the penalties right now would be under the FTC Act. You know, there's no private right of action under the rule, so it's just, you know, FTC enforcement. But under the FTC Act, I want to say the penalties are something like $45,000 per violation. So if you've got 100 employees with non-competes and you keep them in place, that, you know, it adds up real quick.
Well, I think the thing with it is not so much even that you keep them in place, but the idea, you know, you have to actively rescind them.
Right, right.
If you don't actively rescind them, but you can't have them, they're arguably, you know, void under contract law anyway. What's the penalty for not rescinding them? Is that the kind of thing where they actually look at it and say, yeah, you're going to have $45,000?
Yeah, I don't, that I don't know.
I mean, at some point, are you going to be allowed to actually just post a notice in the Daily Legal to say, well, we don't know, our records didn't cover it, but if you were, here it is.
I think the issue is you can't. That's the,
No, it has to be individualized communication.
This also speaks to the last line of the slide. More language. What does this mean? An employer has workers' contact information readily available. It's one of those LY words that can mean as much or as little as you want it to. And I combed the notice, and there is no particular definition or example.
How long does the employer have to track the jobs from an ex-worker takes after he leaves his employer? How long and how detailed must that former employer track his ex-employees or his ex-employees? Now, truthfully, for example, in Missouri, most cases have restricted, upheld, but restricted non-competes to 2 years in time. So, after 2 years, you could argue that the former employer need not track it. I wouldn't trust that judgment, though. For example, right now, an employer doesn't know whether this rule is going to be adopted. Should it start tracking the new workplaces of the employees that leaves during the next, could be 5 years before any kind of rule is adopted? Does the employer have to start tracking his former workers?
I would say no, there's no affirmative obligation to do anything additional than what you're already required to do. So keeping employee records for whatever period of time you're required to keep them, you've got their last known address. That's what you use, unless they've sent you a letter and said this is my new address or something like that to communicate with.
Okay, now there is an exception. Exactly one. The proposed rule would include an exception for non-compete clauses between, reading the wrong one. Does not apply essentially by a person who is selling and business ending or disposing of all the person's ownership interests in the entity, or by a substantial owner who is selling all or substantially all of the business entity's operating assets. So it does not apply in the context of a sale. This is consistent, as I understand, with the...
I have a lot of opinions on this one.
Please interject. It's consistent with the state law who have adopted in California, North Dakota. Okay.
The sentiment is consistent. So, and I've been on the FTC, you know, I was on the public forum, and the woman at the FTC who was one of the principal drafters of this has consistently said, this is not supposed to apply in the sale of business context. But it's not strictly true, because the only exception is, okay, so you've got, what I see are three kind of different buckets. You've got an owner of a business, regardless of what their ownership percentage is, who sells their interest and doesn't stay on with buyer. The rule doesn't apply there, and that's on the next slide from the supplementary information. That's just sale of business, no worker involved. Then you've got sale of business where the owner stays on as a worker. And the only time you can have a non-compete agreement with that person is if they own 25% or more. They have 25% or more ownership interest. So you've got this huge gap where you might have somebody who owns between 0 and 25%. They get paid whatever it is for their ownership interest. If they stay on as a worker, they can't have a non-compete under this rule. And that's a huge issue that's not addressed. And it's inconsistent with, how we've always viewed non-competes. They are much less strictly, a court is much more likely to enforce a non-compete in the sale of business context. These are, people are getting paid for their ownership interest. They're heavily negotiated. Usually everybody's represented. It's a very different situation than just with employees. And so that's to me, at least that's one of the biggest issues I think. And there's not really any, other than them saying this doesn't apply in the sale of business context. There's nothing really that tells us what to do in that situation. And I think that's, and I will say on the FTC's public forum, it's an issue that was raised a lot when people came in to do their comments.
The final point here too is the 25%, as I see, is an arbitrary figure. They suggest that it could go up, could go down as part of the actually solicit input on that.
Yeah.
So it's an arbitrary number.
It's huge, I think, way too much.
And Liz, I think we ought to shift
So the next slide is
number 9.
what we,
Number 8.
Hey,
Well, but I think Liz just covered number 8 in her discussion of the difference between a worker and a 25% plus
okay.
person. So
so this is it's on page 128 of this lovely document. And it reinforces that if the person's not a worker, the non-compete doesn't apply. So in your question, that person wasn't a worker, the rule doesn't apply.
Yeah.
I'm sorry.
It's worker and not employer, employee. That the worker is specifically defined as larger than employee.
Oh yeah, it's very
very broadly defined. I think
It would be a consultant receiving 1099 income.
I think one of the interesting things around the 25% and things like that is, to my take, and you're going to know the rule better than I am, I don't think it states when you have to be owned 25%.
So it's as of the time the person enters into the agreement. So typically you would enter into those agreements at closing or prior to, as a condition of closing. And so at that time they would own it. So it's not after.
Okay, so that's specified.
Yeah.
That's good.
Liz,
Me? Okay.
number 9.
And I've covered a lot of this already, but again, this is, the supplemental information is 210 pages, and the rule is 5 pages. And a lot of what the supplementary information contains at the beginning is studies that the FTC had looked at regarding, how much in compensation employees are losing out on because of non-competes and how detrimental they are. That's a good part of the first 100 pages. But then they go into, the definitions and kind of their reasoning for how they've addressed things. And they also note that there are things that they consider. So as an example, what you just talked about, they've sought comments on this 25% threshold. They've sought comments on, and recognize that perhaps we need a rule where senior executives can be subject to non-competes. People, at certain income levels and things like that. And Illinois, I mentioned earlier, has something like that in the statute that it recently passed. So there is some hope that maybe something like that will be considered. And then this is what we talked about earlier, that the FTC goes through quite a long discussion about, yes, we're going to ban these non-competes, but you guys all have all these other ways of protecting your confidential information. in your customer relationships. You can have a non-solicit, you can have a non-disclosure, you've got trade secret law. But again, that's where that tension comes in of, you can't use these other things to prevent competition, but that's the relief under trade secret laws, an injunction. So there's that tension.
And that would seem that those highly paid or highly skilled workers are really the only ones you care about and not competing.
Well, and so that's the thing. I think many people agree that we shouldn't have non-competes with low-wage earners, with hourly workers, people who don't have access to confidential information, customer relationships, things like that. I think most people can agree that there need to be limitations in that respect. But there are people who occupy positions, whether they're owners or just high-level executives, who, if you don't have, and we were talking about this before we started, if you don't have a non-compete in place, a non-disclosure and a non-solicit is not going to be enough. They cannot just forget, right? They can't unknow what they know. And so in those kinds of situations, sometimes non-competes are the only thing that will provide
Or
sufficient.
probably more important, they've got the contacts, the leads, and the relationships. The NDA, in terms of what they know, seems to be sufficient in most cases I've been involved. But it's those very senior people that can just walk with the business.
But they could just open up shop next door without anything, and they know what to do.
It's the fallout from it is
Yeah.
getting to the outright sale, which has an exception built in.
You've got a question.
Yeah, so I have a question with regards to state law for employees. How does state law affect different aspects of this where it's based on, I think, where the employee lives and where the business is located?
So the FTC rule would be federal law. It will preempt state law. So, non-competes, regardless of where you live, they'll be banned. But for the non-solicitation and, non-disclosure protections, that would, you still have to look to state law. And it depends on where you're enforcing it. Okay, so there's a lot of case law on forum selection and, like California's statute, you can't, if it's a California employee, you can't select any other state's law. That will be void. So different states have different rules on that, but typically it's most appropriate to use the state in which the employee works. Oh, sorry.
So does that mean that this is on the business, let's say the employee moves from California to Georgia? So then change that if the employee doesn't have it?
What do you mean?
So let's say you said for instance, if the employee resides in California, one other state law applies, and that employee then moves, do we then?
Is the employee going to work in Georgia then?
Yes.
I mean, I would think the employer would want to amend that agreement. Well, so that's another thing that the supplementary information talks about. So right now we've got a categorical ban. They've raised the possibility of a rebuttable presumption. So we will presume that non-competes are unlawful unless there's evidentiary support that it should be enforced. The problem with what they've proposed, at least right now, is it looks like they want to use a clear and convincing burden, which is really high. That's like one step below beyond reasonable doubt. So it doesn't really do a whole lot. So if they're going to do a rebuttable presumption, I think it's going to have to look a lot different than what they've discussed. That's what I wanted to make sure to say.
What I was going to mention just for the supplementary information, you may know if it's in there, I don't know if it is or not, is discussion of immigration issues. And the idea that, you have employees that are, or workers that are brought in where an employer is dealing with immigration issues or has dealt with immigration issues around that. And there doesn't seem to be a discussion around, is that something that needs to be exempted out? Is that something, the concern being, could an employee or an employer effectively use a worker's immigration status by not letting them come in and actually sort of gain full work status as a way to force them as a ground for non-compete, without being a non-compete, because really it has nothing to do with competition, it has to do with the fact that they're an immigrant worker. So the example being that they're here on a work visa, but the work visa requires them to be working. A lot of work visas require.
But I think it's really I don't think it would be I mean, if they leave work with that employer, they certainly can do that. It's not the employer's fault that immigration law requires that they transfer their sponsorship or whatever. I think that that's somewhat dependent on the type of visa they have or why they're.
I don't think any return immigration.
But I don't, you know, Mark.
I've practiced immigration law for 10 years. The point that's important to that point is that the most common work visa that people get these days, when they start working in this country, is an H-1B, which requires, the status is only good while that employee is being employed by that employer. So if the employee chooses to leave the employment, that's his problem. I mean, he's created his own problem because the Immigration Service will seek to deport him. If the employer decides to fire him, the employer is causing that person to be deported, and that scares the living daylights out of H-1B employees for the first 3 and maybe 6 years. But it's as I understand it, even under if this rule is adopted, that status won't change.
No, because that's the immigration
Right.
piece of it. Yeah.
Are we on number 10 now, I guess?
Yes.
More mundane consideration is, let's suppose one of you gentlemen, ladies, we have a lady, wants to do something about this rule. Well, you have until, right now, you have until March 20th to file a comment with the FTC. However, the FTC can, and I'm going to guess we all think, is very likely to extend that time because with all the issues we brought up here, it's going to get a whole lot of comments that want more. So if you delay, you might be all right because the deadline may not pass for many months as opposed to March 20th. And that's essentially a 60-day notice. Let's see, you can file it as it now stands until March 20th. And for written comments, you want to write, quote, non-dash compete clause rulemaking matter number, I'm sure you're all writing this down, P201200 on your comment letter, and send it to the Federal Trade Commission, Office of the Secretary, 600 Pennsylvania Avenue Southwest, Washington, D.C. Also, though, apparently you can bring up the FTC's, federal government's website and file through the website, comment through the website.
And Joe?
Yes.
If they give us their email address, we'll send them the slide deck that will have a link.
By the way, that's a good point, because anybody here, lawyer or non-lawyer, who really has understood everything we've said and got it all in place is lying. We recognize that all we can really do here in this session like this is raise the issues and cause you to be concerned and recognize that it's there. So I suggest that you seek that we send you a copy of the slides. Also, it'd be good to help you get to sleep at night. I'd like to talk about, well, wait a minute, no. You're going to talk about auditing, right?
I will do just that. So we were joking beforehand that for employment.
Before you do that, I'm so sorry.
No, please.
I want to just make, so we've got this comment period that could end on March 20th. The FTC does not have any timeline within which it has to issue a final rule. So the FTC has said it's going to review all of the comments that are submitted, so all 15,000, whatever it ends up being. They could take however long they want to review the comments. They could issue a new proposed rule with a new comment period. They could issue something very different than what it looks like now. But whatever is issued will likely be challenged. I personally believe that they will issue a final rule. There was a very strong directive from the president. They've consistently said they're going to issue something. But we've already seen a lot of commentary about the different challenges, and I do think that a number of groups will challenge it, probably in the 5th or 8th Circuit, get an injunction, and this is going to the Supreme Court. So I think it's a long road ahead for this rule, but I do think, again, as I said earlier, that this is the direction we're trending. We've got this legislation pending in Congress. States are passing this legislation. This is where we're going. So you need him.
With that, yes, we were joking before, we have exactly one employment attorney on the panel here today. So the reason Kirk and I were invited, I think, was to talk about what to do if this does go through, and even more so, what business owners, folks that are high levels at respective companies should be doing regardless of what happens here. And it really is intellectual property, and understanding a company's IP assets or trade secrets, how they're dealing with their employees, the contacts that they have. So we'll I guess, speak about it under the pretense that this does go through and what you should do today moving forward, but it's applicable regardless of what happens here. So a comprehensive review and identification of competitive, confidential, and trade secret information. It starts with understanding intellectual property basics, where it's a trade secret and it's something that has economic value that you maintain as a secret. There's no black line rule as to what steps you need to be taking to maintain something as a trade secret. It's understanding what that is, customer list, pricing calculation abilities, marketing data, really anything that business brings economic value. Identifying those and documenting them as, hey, this is a trade secret. The famous Bush's baked beans. Everybody knows about a famous trade secret recipe, right? No one knows the recipe, but they documented the fact that this is being maintained as a trade secret. So that when it goes to litigation, during discovery, they can plead appropriately. Following that initial identification, it's understanding who has access to this to the information itself. Elizabeth made a good point that I think we all agree with it. Low-level, low-wage employees that don't have access to confidential information, we can swallow the pill of not having non-competes for those so much, but the upper level, higher executives that have access to these types of things, identifying them and identifying the information they have. And then understanding the types of protection that's applicable. Is it a trade secret? Is it the difference between confidential information versus proprietary information versus a trade secret? Understanding that proprietary patents are public. They're not protected with a trade secret. It's the whole point of patents, is disclosing what it is that you're doing. That is different than a trade secret patent application that still makes up the intellectual property portfolio of a business. So it's delving into your internal assets and understanding what you have, who has access to it, and the appropriate types of protections that are in place. Next slide, we have a number of bullets that we're going to talk about those in greater detail.
Yep, I'll make sure I'll take this one together. Sorry. That's black out. You want me to jump on this one?
Sure,
Feel free on this one?
Here,
You got a better view of it here, since I'm expecting to look behind me.
Sorry.
You're fine. I think, yeah, a lot of what you really bump into in conjunction with this is the idea of now trying to use these alternate processes, recognizing they are at odds with this law and what they're trying to do behind it, but trying to use those. And I think to Scott's point is that the thing that we bump into a lot of times around these kind of concerns is, why do you have a non-compete in the first place? What is it that you're really trying to do here? And the answer to that is, hey, we've got confidential information that can readily walk out the door and can kill our business. It's identifying what is that information and how do we keep it from walking out the door. And I talked about regularly in conjunction with trade secret, and I think it's one of the big things to keep in mind here. I don't necessarily know if it's one of our options up there, but I know we start with, we can start with the shared access to shared files. Is there a technical solution to this? And the technical solution is the employee simply doesn't have it. And is that basically the best solution to all of this, is to say, hey, legally I can't have a non-compete, legally I may not need a non-compete because this is now a worker who simply cannot leave with this information. Now, around that, you then bump into the issues of how do you implement that kind of technical solution? Do you bump into things like de factos? What do you bump into around how do you keep it from going out? So the example of like things I can bump into, and again, I'll use the one up here, we have share access to shared files on a need to access basis only. Another way to do it is simply hey, instead of your employee accessing things from their home computer or from their home phone, here's the company laptop, here's the company phone, and guess what you have to return before you leave. And that's the only way to access this information, is via those machines. And we've effectively locked down the information, we've imposed a technical solution, as a way to get around this. And in many respects, that may be your first line of defense once you identify what these things are, where the lawyers aren't involved at all.
It goes to your IT professionals that are setting all these things up. Actually, I met with our IT professional beginning of January, scared me to death about all of the things that we are not doing as a firm. For example, use Google Server to host all of our documents, and then use Outlook on our local computers. I'm not an IT person. That is all pulled to my local computer every time I go on my email. So a nefarious employee that is leaving, you might think your servers are secure. They're accessing that information on their computer and can retrieve it once they're departed, if they have returned the computer.
And that's, just one of the things that you can be doing. One of the things I always counsel clients on when you're terminating someone, when they're in that termination meeting, that's when you're shutting down all of their access, taking away all of their equipment, because after they leave that meeting, you don't want them going back to their desk and taking that information.
The other point there too is if you are an employer and you know someone is coming to you, questioning them about their particular former employer, you don't have to delve into confidential information, but understanding the projects that they may have worked on that's not protected with an NDA, and making sure that you're not running afoul of the confidentiality agreement that they are still under based on their former employee. Simultaneously, putting if you employee leaves to go to some other company, competitor, or otherwise, putting that new employer on notice that, hey, this employee at the time was aware of confidential information. If something comes up, then you are now have an obligation to notify us about that so we can avoid any breaches. So
I think one of the interesting ones you get into as well in conjunction with this is, particularly talking about the nature of employment agreements, if you start putting in some of these technical protections and you say something like, you are only allowed to utilize firm email at your firm email, you can't have it sent to a private email account. If that's now part of an employment agreement, if you now have an employee violate that employment agreement, you need to terminate them, potentially get rid of them. Are we now going to be running afoul potentially of the fact that we've got to get rid of employees because they would do something which would violate a non-compete before they could, we can't have a non-compete or before they would actually leave. And are we going to have problems around that? And it's something to just keep in mind. It's one of the ones that when I talk to people a lot of times, I said, when you put a trade secret policy in place that says, hey, you have to carry out these procedures, as soon as you say you have to carry out those procedures, you need to be ready to enforce them. And that means that sometimes you have to get rid of employees, get rid of workers who violate them, or at least have a procedure for what that's going to be. Have some form of disciplinary process. Otherwise, it's meaningless. But you now end up with a concern of this person did that, but we don't really want to get rid of them. Well, now what do we do? And that's what we've fallen back again on that trade secret practice. We've got these laws that are in place for doing trade secret, but they're imperfect fit for what we see here. And if nothing else, and again, I think to your point of well, what is a trade secret? The key element of trade secret is it's secret. You're trying to keep it secret. And so...
It could be your list of customers that's on, your company website as, these are our great customers. The people on your customer list is not a trade secret.
Yeah, and, so it's, hey, we have, we're going to keep our formula for the recipe, secret. Okay, we keep it in the safe. Who has access to the safe? Well, there's no photocopying. What happens if somebody does? What do we do with the photocopy? Okay, we have a violation of our trade secret agreement. What do we do? Then there's the nature of, well, if the person doesn't have a non-compete, hey, they did violate our employment agreement at the time. They made a copy of our recipe. They took it with them. Now it's out. I no longer have a non-compete clause of anything that I can potentially say, as a way to come back after them. But I do still have this ability to come after them in conjunction with, trade secret law or something like that. But I think we're going to start seeing much more of that inherent conflict between these two, of the needing to use trade secret law, and I think it's primarily trade secret law where we're going to see this as an imperfect solution.
Well, the other thing, I would say in the last 5 years, we've definitely seen courts looking at non-competes more carefully, being less inclined to issue temporary restraining orders, preliminary and permanent injunctions, and a lot of them being less inclined to blue pencil any overly broad provisions, even if they have the ability to do so. So what we have been moving toward is making sure that our other provisions are tightened up. So the non-solicitation of customer provisions, you can't prevent someone from soliciting customers that they never had a relationship with. That won't be upheld, even in Missouri. So you've got to make sure that you're tightening up those provisions and really actually prohibiting only the things that are going to cause you that damage. So, you can't solicit any customers with whom you had, material business contact or about whom you had access to confidential information. And limiting that for a period of time, the period of time that you need to get somebody else in place to solidify that customer relationship. It can't be for 10 years. Probably a year, in most cases, is what's going to be enforceable. And so that's going to be really important if we have to start pulling those non-compete provisions out of those agreements. Also making sure that you've got really good severability language. So I don't like creating all kinds of new provisions in a contract, making it longer, but I've started pulling things out and making each one its own separate paragraphs, that if we do have to rescind, we can just take that right out. Or if a court has to, is reviewing it, deciding whether or not to enforce it, I'm not talking to you. Then the court can just strike it. There's no rewriting. It's much easier, and they're much more inclined to do that.
I think that comment's a really good one, because one of the things you do see in employment contracts a lot is non-competition and non-solicitation clause.
Now
Put together.
I make them separate so that a court can do that. So no rewriting, just pull it right out.
Another one I think is really valuable when we talk about this idea of solutions around, what are some of the other solutions here. Another one to really be contemplating is, when we're talking about trade secret provisions, trade secret's a really useful way to get around the non-compete, and we sort of see the competition. But you also then bump into the idea of, can we just avoid trade secret as a whole? And now should we do something like, let's go for patent protection on something which may have been a trade secret beforehand, on the idea that, hey, even if the employee leaves with it, there's nothing they can do about it. Because now the competitor can't use it at all. And that's also a worthwhile thing to be potentially considering, is can we resolve this, again, not as a truly legal solution, not necessarily technical in the thing behind it, but looking at it and saying, if we go a patent route instead of a trade secret route in conjunction with this particular technology, whatever it is that we may have, it doesn't matter whether an employee leaves, it doesn't matter if it's independently developed, they still can't have it. So is that a way around? I was questioning that.
Yeah, so I had a question about that. So usually like trade secrets is because you don't want the patent so that your competitor can't hold the file.
Exactly.
And you create a 20% variation. So in that type of situation, is there like another route you would recommend if you're in a position where you don't want that publicly available?
I think the problem you bump into is it's, the way they've sort of set the rules up, you basically have trade secret and patent. They're diametrically opposite. One has to be completely secret, one has to be completely public. There's no, half disclosure. There's a little bit, I think, around software code. I think you probably agree with me in that. There's a kind of way to be partially public and not quite totally public.
Different topic for a different time.
Topic for a different
Software patenting. Put it that way.
Well, even software copyright, actually.
And copyright is probably the best way, because for copyright software in particular, you don't have to submit the whole source code in snippets. You can maintain traits of your copyright. The way we do it, and again, they are diametrically opposite. The point of patents is that I disclose what it is I'm doing, so that Joe can take it and improve it, and patent his invention, so on and so forth. We use what we call trade secret applications, where the client may not know whether or not they're going to let this issue, in that instance, publish. The closest that I've gotten to actually rescinding a patent, and a lot of patent people a month before, we said, okay, this is not going to happen, we're not going to let this go. So you can begin down the patent path, which is years, and then later on, depending on the development of the business and where you're going, where you're at, determine whether or not you're going to let that patent issue, continue prosecuting it where you're at, or maintain it as a trade secret. The second part of this, the real more underlying part from an employment perspective, is in employment contracts, making sure that ownership is correct. Whereas when I hire someone, I'm obtaining their rights and interests in the contributions that they're making to particular inventions, copyright, whatever the ultimate protection becomes. You own that. We see lots of times where, for example, independent contractors now, they have this broad definition of worker. If I don't have a proper work for hire agreement in place, secondary to that assignment, it supersedes it, work for hire fall apart for some reason, I could be left with this individual taking, they do my work, they give him this product, and then he changes it by a fraction of percent and sells it to someone else. You want to make sure you have the proper assignment where you, the employer, now own that particular work product that you ultimately paid for.
I think that is, your comment with it is, and I think it's a very good one, is that one of the things I think we've seen a lot is that people are very good with employees about making sure they have these kind of, employment assignments, the invention assignments, copyright assignment type clauses, with the recognition that worker is going to be a lot broader than just that. You may need to have these with people you wouldn't necessarily have them with, and that may be a difficult negotiation. When you're talking about the fact that I have to have this with a volunteer that's interning and I'm not paying.
Well, that's unpaid interns are
I know,
a whole other issue.
but the things behind it, where I'm saying, is that person a worker?
Right.
And now suddenly I have to have an agreement with them that says I own what they create in order to protect myself because they're covered as a worker under a non-compete. I bump into these kind of things that I can't otherwise protect myself, and I think it's to exactly your comment. We're going to be butting heads, as to exactly how to deal with those type of things. And those types of concerns are now going to potentially come to the forefront. Independent contractors is the obvious one. Mm-hmm. If you're not having these kind of agreements with independent contractors, you're going to have major problems, around this, because you do need to make sure you own those inventions, and that you also need to make sure, as part of it, that they're telling you about them. So not just that you own them, but they have an affirmative obligation to tell you that they came up with this stuff, as pieces of it. And again, to your comment to the slide, we have it in conjunction with audits. That's a lot of what I think this is going to be, and where we're really looking at. We're going to have to trigger from this law becoming what it is. One of the hard parts is we need to be doing those audits now, because we don't know what's going to happen. Because we just don't know what's going to happen with the FTC provisions. And at least in my mind, I'm not an employment lawyer anymore, but to me it really felt like this did kind of come out of nowhere. It was headed in that direction, but the FTC just kind of jumped, leapfrogged from it and said no, none at all.
Yeah, I think yes and no, it was surprising, but they definitely took it to another level.
Yeah. Yeah, that's again. That's what I mean. We're headed that direction, but it's the we were 100 yards in, and they just said to finish the marathon. That kind of thing with it. Now those are the kind of things I think we're going to have to deal with around it. There's a lot of how can you use these things? That's what it is. We're going to have to work the things out. You're going to need to tighten the IP provisions in employment agreements and in agreements with with contractors, with unpaid interns. I'm doing that just to provoke you. What do we have to do something with it? What can we impose for technical solutions to put out there? What do we have to your comment, and I think to the question of, is there some other way to put things out there using things like, we've done the same kind of thing, the trade secret applications, the idea where you're filing a patent application with the decision of somewhere along the line, we're going to decide whether or not this is a trade secret. And if we decide it's a trade secret, we may have spent, $40,000 going down the patent path, and then we're saying, no, we're getting nothing out of it. We're backing off on this because we decided we now need to keep it as a trade secret, but that's a way to do it. The advantage of doing something like that is you have the record at the patent office as to how this was created, when it was created, whose it is. And that's something I know, from when I first started practicing, that was one of the things that we used to do, not so much to get around this, but to go the opposite direction. The idea is you would file patent applications because they would stay secret for a little while, and then they become sort of hidden publications. Nobody knew they were published until it was too late to do anything about it. Some of that same type of idea. Do you now do something where it says, I'm going to file a patent application, particularly like a provisional patent application, which will never be public if you file no related, non-provisional application off of it. Do I file a provisional application with, hey, here's this thing that the person came up with, which may not even be patentable, but I'm going to file a provisional application on it, get that record at the United States Patent and Trademark Office, which is indisputable, that it was filed, this is what it disclosed, and everything else. And now when the person leaves, I can say, no, that's definitively a trade secret, because I have a record of what it was that was filed at the Patent Office, which is a bizarre procedure. We're literally using the Patent Office as a way to prove trade secret.
How many people here are lawyers who are going to seek CLE credit? 1, 2, 3.
Our lawyers are what?
How many people,
Lawyers
how many
seeking
listeners
CLE.
are lawyers who are here to
Had
get
their money
CLE credit?
polluted by going through the training.
I have Google, does that count?
My question goes to how long we ought to go. We can go an hour and a half and get an hour and a half credit.
Get us another slide.
Pardon?
Another slide.
Okay, one more
Yeah,
slide.
right.
I think it's the subdivision.
Yeah.
Well, so this one really relates to protecting confidential information in terms of transactions. And it's a lot of the same stuff that they talked about, and I'm sure that you guys do that review in connection with transactions as well, and just making sure that, well, first of all, what I would say is, I strongly recommend continuing to include non-compete provisions in deal documents, in the employment agreements, things like that, but making sure that you're doing the things that we talked about, like making them separate provisions, making sure that they're severable. But I think even more importantly is looking at being really intentional about identifying the assets that you're purchasing, so especially the intellectual property assets. Instead of having just sort of a catch-all, purchased assets that include undefined intellectual property, we need to be a little bit more specific, because we need to make sure that we're protecting all of that. I think we're also going to see, it's going to have an impact on the purchase price. What was the non-compete provision? What was the value of that? And how are we going to address that? And then the thing about getting creative with arrangements with key employees, do we want to do like a garden leave kind of period of time to tie that person up who otherwise couldn't have a non-compete? I think, Massachusetts has something like that. Something that was mentioned a couple times on the FTC's public forum is, they're basically being paid to sit out. They're technically employed, and so we can have a restriction in place during that period of time. So I think that's what we're going to have to kind of see if something like this goes into effect. We're going to have to get a little bit creative.
The thing that I really probably want to talk about is for lack of a better way of putting it, the paid to do nothing as an employee type of clause, which I know if anyone here's sold a small business, that happens. You get these things where it comes in and sort of, it's the, hey, yes, we're going to pay you for a year to be a consultant.
transition services.
Yeah, and you know, those kind of things with it, where what the answer to it is you're going to sit in an office
Or at home.
or at home and
Or
watch
on
the
the beach.
game. You know, because that's your job. As what is we may have to ask you occasional questions. We may, you know, want to, but the reality is you're not really working. But you're a employee, which without any question is defined as a worker.
Or a consultant.
Or a consultant.
Which
or,
is
you know,
also
something
a
like
Just
that.
selling off your freedom, God.
Yeah. And, you know, is that what non-compete's going to become? Is non-compete's going to become, and that's again, get back to my point sort of the beginning, what's conclusion of employment? You know, when do we get into the idea, hey, your employment is concluded? You know, meet these questions. One thing I want to throw in at the end of this, and as I was going through and prepping for this, I realized there was a slide we should have in here that we didn't. And that slide was basically the one thing to keep in mind if you're now on the other side of this. So you're now looking at saying, I want to poach employees. I want to bring, you know, sort of things in conjunction with it. The fact that they can't have a non-compete is not going to necessarily clear to do. You still need to be careful. You don't want to go into things and coming in and saying, hey, since there are no more non-competes, I can freely go and grab whoever. They can bring all this technology over with them, things like that. Don't think this is a free-for-all. I mean, we really looked at it and said, you know, yes, this is going to create problems, but don't look at it and say, this means you can go out and poach employees.
I had, when this rule came out, I had a number of calls from people, clients, we're looking to hire this person, they've got a non-compete. Well, with this rule, we're good to go, right? And it's like, well, no, not right now. And even if it does become effective, that this contract that you sent me has a non-solicitation provision. It has a, you know, non-solicitation of customers, non-solicitation of employees. It's got, you know, non-disclosure. Those things are still in place, and those things still need to be honored. And so, you know, yes, it's easier in terms of, you know, they can go 5 miles down the road and work for a competitor. They still have to be walled off from a lot of things. And you know about it.
Let me ask you something. I'm listening, gleaning all this new knowledge from all your attorneys. I was at the beginning, I was thinking, I don't understand anything you're talking about, but I wonder what the bias is from the Federal Trade Commission. Is it to protect the worker or the employee, or is it to protect business owners? And I've gone back and forth on that, just trying to answer my own questions, listening to what you guys said. Do you have an answer to that, that in general, the Federal Trade Commission is out to protect the employer or
The worker.
I think
I'd be interested in,
with most
before
lawyers,
you agree.
with most lawyers, the answer is yes, you should go back and forth.
I think 100%, well, 100% they say it's to protect the worker.
Yeah.
That's what they say. But there's lots of room to play.
Well, a lot of the causation, I think, has to do with the perceived overuse of non-competes with people who make beds in hotels, and they work for cleaners at the front desk, taking in people's clothes for cleaning, etc. Subject to non-compete clauses, which it's pretty obviously, in most people's thinking, not really fair.
Well, it's restriction of trade. I was held to a non-compete while I was a minimum wage production assistant at a TV station right at a college in Mobile, Alabama. They had the janitor on a no-compete within 60 miles of the broadcast tower. I have labor to sell, and I can't sell it across town. You know, it's a restriction of trade. I had no trade secrets, but they said that I had vital trade secrets, and you know.
And I that's a great point, and I think that's exactly what does need to be addressed, and what some of these state statutes do address. But the FTC just went, you know what, we're just gonna ban it all. And it may be, you made this point earlier when we were talking, it may be that they did that so that they have a lot of room to walk it back.
Sure. Well, I think that one I just want to sort of say with the question is sort of a personal thing and looking at it. I also kind of wonder how much of this is we're doing this to get people to look at it and say, no, wait, that type of non-compete really should never exist. And so to the idea of like, what are they going to issue in conjunction with a rule here, in some sense you look at it and say, yes, they're going to have a final rulemaking. I kind of also look at it and say, are they ever going to have a final rulemaking? Because there's a whole lot of value to leaving it open as to whether or not they'll pass something like this and maybe it'll go away.
Yeah, so a couple things on that. So the FTC rule is going to be subject to a ton of challenges. So they've taken, the FTC Act, something that's been in place for a long time, and they've said, well, but now, even though we've had hundreds of years with non-competes, we don't think that they're okay anymore under this act that's always been in place. And so that's going to be a big issue. There's definitely some political things going on. I don't know how many of you saw the Valentine's Day op-ed in the Wall Street Journal with the lone Republican commissioner announcing she's going to resign. So we've got 3 Democrats on the commission. They can still issue this final rule, but there is a lot of infighting going on. We've also got the Workforce Mobility Act pending that I doubt that that's going to pass either, but if it did pass, that's definitely going to be less subject to scrutiny and these legal challenges. I'm
going to throw one more out there, just sort of, what are we going to see in conjunction with the FTC? What does this mean for a labor union closed shop?
Doesn't it say though that it's, there's something here about CDAs.
There's mentions in it in conjunction with it, but are we going to bump into things where we're going to start seeing, hey, we've got an FTC rule that comes out very broadly, and then you suddenly see legal challenges in the fact that this could apply somewhere where it was never intended to.
Yeah, well, the other thing, I think one of the negative impacts we're going to see is things like, incentives that are provided to employees, profits, interest, or rollover equity, things like that we always include restrictive covenants in. I think that companies are going to be less inclined to provide those benefits to employees if they can't get those protections. And so I think that there is going to be a negative impact in that way.
Yeah. My take behind it, I think a lot of what I see behind this proposed legislation is real concern with the idea that essentially non-competes are being applied to too many kinds of employees. The concern being, we're not sure who they should apply to. And the FTC I don't think has a good definition of that. That's sort of a comment. The states have gone different ways. We have a couple different, sort of proposals here, but we don't have, trying to say naturally this is what we want to do, this is what the federal government's going to make as a position. The FTC struggling. And that's, I think, a little bit of why they've asked for these comments, why they're getting so many comments, and in some sense, maybe why the rule is so open, is looking for what do we think this should be, how do we think we do handle this question, and then also dealing with we have these other forms of law, like the Uniform Trade Secrets Act, which they can't overturn. And that's legislation. There's no way the FTC can say that doesn't apply. And so how do we deal with that around these other problems? And exactly your comment, and I love the comment sort of with it. Does the janitor have trade secrets? You kind of look and say, oh, or could they? At the same time, maybe if they looked in a file cabinet, they could. If that file cabinet wasn't locked, they could have access to something, especially if they had to clean something, maybe, cleaning inside a protected area.
But that's a perfect example of where an employer has protection through a non-disclosure.
Yeah.
Right, so the janitor isn't going to look in most janitors, all janitors, most won't look in the file cabinet and get that secret recipe and be able to open up a business and compete. But a higher level executive who might have been involved in this might be able to do that because they've got the broader context of the business and things like that. And so that's where a non-disclosure might not provide sufficient protection.
I think with that, the janitor is the disadvantaged individual that will not be able to fight a standard non-compete there, whereas the high executive, potentially the employer that brings them on would be able to get that. So there probably isn't that median where there's a segregation of employee level.
Yeah, well, and that's, so that the FTC forum, which I think was recorded if anybody wants to go watch it, but they had a lot of lower wage earners and people who were subject to non-competes talking about how it impacted their lives. and I personally think that there do need to be limitations placed on, the restrictions of different levels of employees, depending on what they do, and it really needs to be tailored to what they do. Because some of these stories were relocating families to other states when they're low-wage earners, like I think we all agree, that's not the time, or that's not the place for a non-compete.
That's not what it's for.
But I think the FTC went too far.
I'd just be curious in your opinions about if the rules go through substantially as suggested, what's the effect between large companies, well-capitalized companies, and entrepreneurial startups if these rules were to apply? Would there be a net beneficiary one way or the other?
I think,
For example, if you can't limit the non-compete, why would a large company buy a small company when they could just simply, through understanding the inapplicability of non-compete, to just bring the people over and thereby, in effect, stop or strangulate the formation of small businesses to do certain things?
I think you actually go the other way, because you can have the non-compete at the purchase. So in the event that you do purchase the company.
No, that's what I'm saying, before you're even at that point.
Circumvent.
When you're in transition of forming the business, does it operate to the advantage of either smaller businesses trying to start as compared to investors that may be interested in their success, and larger entities already in existence being able to now theorize, I can just simply poach people and have them come into my business because I don't have non-competes.
Well, I think there's already, to some extent, that issue already exists because those big companies
Well, of course it exists.
they're fine spending all kinds of money to fight the non-compete that the small company can't pay to enforce.
But now they wouldn't have to fight it, would they?
Right, so, but I think.
So it's
from
not
that
just, like I said, so
perspective-
it's not just a worker, that's the first thing I thought, it's not just workers, but it could be where you are in the economic
Sure.
schedule or scale of wealth intensity, if
to
you
give you the lawyer's answer,
what?
to give you the lawyer's answer, it depends.
Yeah.
Naturally.
And I don't mean to smoke that discussion either, but it's fact intensive. I think we've got enough for an hour and a half of disease.
That's what you read there.
So, related people need CLEs? Okay. Thank you all for attending, and the panel was spectacular. I really appreciate the comments and the good interplay. Nobody had sharp elbows.
Kate,
Everybody behaved. Thank you all.
Thank you.
Thanks for inviting us.
And if you need any, like, kind letters written, I'll do that.